Morning, Steve. Morning, Jeff.
Hello.
How are you this morning?
Good.
Good. Are you in Isla Morada for champagne and bagels?
I am.
Oh, sounds good. Give it another minute or two and then we'll get started. So good morning, everybody.
Good morning, Ruth.
Good
How's
morning,
everybody?
Ruth.
Good morning. How's everybody?
Good.
Good.
How are you?
I'm just fine, thank you. Morning, Alicia.
Good morning.
How's everything in Key West?
Oh, it's good.
Well, that's good.
How about you guys? Everything good?
Everything seems to be fine in Marathon.
Right. No rain?
Not right now, no. Hello, Jen, you're back now?
Hi there. Yes, I am back.
Okay. And good morning, Elizabeth and Cheryl Ann and Amanda and Lauren and Shanti.
Good
So,
morning. Good morning.
okay. Alrighty. So it's a couple minutes after 10. So we might as well get started. Remember, this is always interactive. So stop me and ask questions and ask Jeff questions. He's here too. So between the two of us, hopefully we can answer all your questions and make things a little bit clearer to you. Um, so we're going to look at some things today that we, as I said yesterday in sales meeting, we're going to look at default and dispute resolution and force majeure and risk of loss. Hopefully, some of those you won't have to encounter. The most common thing you probably will encounter is buyer default. It's very rare to have a seller default, but we do encounter buyer defaults from time to time. As far as force majeure, we do live in a hurricane-prone area, and we'll talk about that. And we are going into hurricane season, so I guess it's timely. And then risk of loss kind of ties somewhat into that. But risk of loss can happen at any time because it's a casualty loss. So with that, We'll get started, and please just stop me if you have any questions at all, okay? Okay, so this is actually the sixth session that we've done on contracts, and so far we've been looking strictly at the as-is residential. So we're coming to the end of that. We're going to start looking at the vacant land contract in the next session. So I know you're all very excited about that possibility. So that's what we're going to do. Okay, so where are we starting? Well, we're going to start with what I just talked about. This is the subjects that we're going to talk about today. So again, stop me. Jeff is here. I don't know if Frank is here yet or not, but stop us, ask us, and let us, any questions at all. So we're going to start with default. So under the as-is contract, okay, default occurs when a party fails to perform a material obligation required by the contract within the time frame specified. So that's pretty straightforward. That applies to every contract, every agreement that you're in. So some other examples would be what? It would be a listing agreement, a buyer-broker agreement, okay? Anytime there is an agreement between two parties and there are terms where one party or each party has to perform and they fail to perform within the bounds of that contract, they fall into default. Okay. Okay. So what would be some of the buyer defaults? Well, failing to make an escrow deposit on time or failing to make a full escrow deposit on time. Okay. Not a partial. It has to be a full amount. Okay. Failure to obtain financing with the loan approval period, unless they're protected by the financing contingencies. So in that loan approval provision in the contract, buyers can elect if they feel, they may not have loan approval within the loan approval period, but they feel confident they're going to get it. So they'll let the loan approval pass without providing the loan approval and move right to closing because they have a confidence factor, right? However, in the situation where the buyer is unable, they're going to be denied or they have been denied, and the actual denial letter has not been delivered to the seller prior to the expiration of the loan approval, that puts the buyer in default. Okay, questions about that? In the financing provision, there is a stipulation about when the buyer has to make application for their financing. The default in the contract is 5 days. Okay. I lost a deal. I not personally, but when I was working in Big Pine, we lost a deal because there was a seller who wanted to get out, had a very astute agent, went through the contract looking for a loophole and found that one. Okay. So if they don't make their financing application on time, they're in default. If they fail to close, which is pretty evident, if they fail to close, they're in default. Or they didn't meet any other contingencies in the contract. So it could be if they have a sale of buyer's property contingency, it says that they have to provide a copy of that contract within a certain period to the seller. Well, that is an obligation that the buyer has. If they fail to do that, technically they're in default. Okay. If you write into the contract that the buyer has to provide proof of funds within so many days of the effective date, they fail to do that, they're in default. Does anybody have any other examples of where a buyer is in default that we didn't cover here? No? Okay. All right. So what happens then when the buyer defaults? Well, the seller is then entitled to recover the escrow deposit. In the listing agreement, we refer to that as the retained deposit, okay? And that covers liquidated damages for the seller, and the seller is limited to that amount. So what happens when that happens? Well, the seller is going to initiate a release and cancellation of the contract, okay, which we're going to look at in a minute, and it was going to include the distribution of funds. Okay, so in our case, and I took the provision out of the listing agreement, in our case, the seller would only get 50% of that amount, and Coldwell Banker Schmidt gets the other 50% when the buyer's in default. So if you have that situation, which unfortunately you all will or have, when you write that release and cancellation, you have to make sure that you're not giving the seller 100% of that retained deposit. Okay. Questions about that? This is what it would look like. Okay, I just assumed, I think there was a $50,000 escrow, so it would be 25,000 to the seller, 25,000 to us. Unless, of course, you've negotiated a different amount in the retained deposits clause of the listing agreement. Okay. Okay. So this is the actual provision in the contract that deals with buyer default. If buyer fails, neglects, or refuses to perform buyer's obligations under the contract, including payment of deposit within the time specified, seller may elect to recover and retain the deposit for the account of the seller as agreed upon liquidated damages. So that caps the seller. The seller can't go after anything more than that amount. Okay. Questions about that? And this paragraph will extend beyond closing this term. Okay. So now we're going to move on to seller default. So again, doesn't happen that often, but it can. So seller fails to deliver marketable title, fails to close on agreed date, fails to comply with contingencies, and this is probably the more common problems, is required to close open expired permits or code violations and hasn't done that prior to closing. So there are ways around that. Okay, you can agree to close and hold funds in escrow, right? You can do that. All right. Fails to provide rental information if required. So if in the contract we have vacation rentals or long-term rentals, there's a provision in there that the seller has to provide the buyer with all that documentation within 5 days from the effective date. Well, if they don't do that, they're not performing. Theoretically, they would be in default. Okay, so it's whenever you fail to comply with any other contract provisions. Okay, right? So what are the rights of the buyer then? Okay, if the seller defaults, well, the buyer then gets all their escrow back. And again, you have to do a release and cancellation form, but in this case, 100% disbursement to the buyer. And depending on the circumstances of the seller default, depending on what it is, the buyer could pursue the seller for a specific performance for failure to close. But again, it depends on the situation. Or they could seek actual damages. Okay, so the buyer has more expansive remedies than the seller. But again, it's very rare that seller defaults. Jeff, have you had a seller default recently?
We have had it happen before, where they just changed their mind.
Yeah.
Yeah. So
Yeah.
it could happen.
Yeah. That's the last one I had was they changed their mind because they were staying in the Keys and they couldn't find another home that they liked. So it ended up a negotiated settlement between the buyer and the seller.
Mhm.
So, okay. Okay, and this is the provision for seller default. It's very similar to the buyer default. It's just that the buyer has more remedies available to them. Okay. So now you have a default situation, and under the contract, there's a dispute resolution provision, okay, that governs how conflicts are handled before parties can go to court. So in this case, all right, the contract requires mandatory mediation before litigation if the two parties can't resolve the differences themselves, okay? And the parties then must attempt mediation, and it applies to most disputes arising out of the contract. The commercial contract, when we look at that one, has I think, a better provision addressing this. It's clearer. So, but again, those are the steps. Buyer and seller try to resolve the dispute. If they can't, there's mandatory mediation, and we'll talk a little bit more about it in a second here. And then if that doesn't work, then of course they can go into litigation. So what are the examples of disputes that end up in this situation? Well, there's a disagreement over the escrow deposit. That's the most common one. Okay, buyer and seller do not agree. Default, buyer versus seller, failure to close, contract interpretation issues. Okay, so buyer and seller have 10 days after the date of conflicting demands for the escrow deposit to resolve the dispute, failing which they must submit to mediation with a Florida certified real estate mediator. However, injunctive relief, which is legal action, can be sought without first attempting mediation. If you have ever had to go to mediation with your buyer and seller and you sit there and listen, it can get, it's interesting, I will say that. But it can be a very, shall we say, unpleasant experience. So, all right, so this is the actual dispute resolution clause, and it talks about unresolved controversies and claims and other matters between the buyer and seller arising out of the contract. Okay. Buyer and seller will have 10 days after the date of conflicting demands for the deposit are made to attempt to resolve it, which we just talked about. If not, they have to go into mediation with a Florida certified real estate mediator. But again, if they can elect to skip this and go right into look for injunctive relief. So who pays for all this? Well, under the contract, it's pretty clear. The parties will split equally any mediation fee occurred in any mediation permitted by the contract, and each party will pay their own costs, expenses, and fees, including attorney's fees incurred conducting during the mediation. In any litigation permitted by the contract, the prevailing party will be entitled to recover from the non-prevailing party cost of fees, including reasonable attorney's fees incurred in conducting the litigation. It's always interesting to me what the definition is of reasonable attorney's fees. Okay. Anybody have to go through this besides me? And I'm sure Jeff has gone through it too. Any of you gone through mediation or a situation that ended up in injunctive relief? Well, that's good that you haven't gone through it. Okay, so we are coming upon hurricane season. Okay, where our risk of force majeure is greater than probably the rest of the year, but that's not to say other things can't happen. So in the contract, what is force majeure? Okay, it's a delay. It's not a cancellation of the contract. It's a provision that applies when events outside the party's control prevent timely performance. So it can be caused by a hurricane, a tropical storm, flooding, fires, acts of God, government action, shutdowns, evacuation orders, epidemics, pandemics, labor strikes, or supply disruptions. When we look at the clause from the actual contract, it expands those things a little bit more. But most typically, it is going to be due usually to a storm of some kind. Okay. Although recent experience with pandemics did cause a few disruptions, but it's typically related to a storm, at least here in Florida. So when does force majeure begin? It begins at the point a force majeure event prevents or delays a party from performing contractual obligation. Okay, there's two qualifiers. Okay, that the event actually does prevent performance. Okay, and it will affect the transaction. Okay. What triggers it? Force majeure applies when an event beyond the party's control prevents performance, and the delay is directly tied to that event. So offices are closed, we can't conduct inspections, we can't bind insurance, the lender has halted processing. Those of us who have been through a lot of hurricanes here, you know what can happen. No power, no internet, all of those things can prevent performance under the contract. So the provision in the contract automatically extends deadlines. Okay. And there is no written modification required. So we're going to take a look at that now. So at all time periods affected by force majeure event, including the closing date, will be extended a reasonable time up to 7 days after the first force majeure event no longer prevents performance. However, if the event continues to prevent performance more than 30 days beyond the closing date, either party may terminate the contract. So just remember, force majeure is a delay. It is not a cancellation, an automatic cancellation or termination of the contract. Questions so far about this? No? Okay. So what it does, when it occurs, contract deadlines are extended for the period the event prevents performance, applies to all time periods, closing date, financing, inspection, escrow deposit, all of those things, okay? Extension lasts up to 7 days after the event ends. Okay. What it doesn't do, it does not automatically terminate the contract. It does not excuse performance entirely, and it does not shift risk of loss. Okay. Okay. It's self-executing under the contract. Okay, which means you don't have to write an addendum to the contract as it relates to this. Once a qualifying event occurs, the contract automatically extends the time periods. So what happens is just because we have a hurricane, all right, or we have some kind of a storm, that doesn't trigger force majeure. It only triggers it if, as a result of that hurricane or that storm, performance against the contract is halted. And it triggers at the time when the first event occurs. So the first event would be, let's say you have a closing and we've had a hurricane. So your force majeure event has prevented the closing from happening. So it triggers as of that date that the closing was to occur, not the date the hurricane blew through. Okay. Okay. Even though it's automatic in the contract, it is, you still have documentation that you have to do, right? So you do need to send written notice, an email confirming to the force majeure event, the date it began, which deadlines are impacted, and this will avoid any disputes afterwards. So where is that? Who are you notifying? If you're representing the buyer, the two agents are communicating, and there's going to be an email from the buyer's agent to the listing agent. And of course, you're going to notify everybody else that's involved, attorneys, the closing agent, everybody that's involved, okay, needs to know that there is a force majeure event. But I have a question for you. So this happened to me a couple of years ago. Does the force majeure event have to occur here to impact performance against the contract?
No.
Is that Christina Parker? Christina Davis, rather?
Yes, it is.
Very good. That's the correct answer. And why are you saying no?
Because if the party is from Philadelphia and the force majeure event happens in Philadelphia and it prevents them from moving forward, it would still
Exactly.
count.
Absolutely. Is everybody clear on that? Because I had a discussion about this about a week or so ago with someone who said, oh no, it can only be exercised if it happens here in the local venue. Like, no, because I had that. If you guys remember, there was a horrible ice storm 5 or 6 years ago that affected, I think it was like Tennessee and Virginia and everything. And it brought everything in that part of the country to a halt for about almost a week. Power lines were down. Nothing was operating. Banks were closed. No internet. And we had closing. We had a
I
closing.
remember that.
Yep. Yep. And we had a closing that was supposed to occur. So the force majeure event occurred elsewhere, but we couldn't close here. So it's not just locally. You can be impacted by it, regardless of where it happens. Anything that will affect the performance of the contract and delays it. Okay, so again, it doesn't have to be just here. I just want to go back to attorney's fees and dispute resolution. If there is going to be injunctive relief, all of that has to occur here in Monroe County. Okay. That's what the contract says. The contract says that any legal disputes have to be dealt with within the venue, which is Monroe County. And that also applies to our listing agreement. Okay. Okay. So because it self-triggers in the contract, you just have to give notice that, the force majeure has been enacted. But when would you actually use an addendum? An addendum becomes appropriate if the parties want to extend deadlines beyond what force majeure allows. So we know it says 7 days. And then it also talks about if it goes beyond 30 days beyond the original closing date. So if those are the cases, that's when you would use an addendum to modify the time periods that are already stipulated in the force majeure provision. Let's say you have to modify terms, not just extend times. Okay, there's something occurring with this transaction now that we have to modify some terms. Does anybody know what those things might be? No? Okay. All right, so you've got time, but you may have something else now that's occurred. Okay? Maybe you want to have a new inspection. Maybe you want to, maybe those are the things that there are other things that you want to have occur now as a result of this. Okay? Inspection period, or if you're beyond inspection period, a new inspection period related to what's ever occurred here. Okay? And then we're going to talk about how force majeure and risk of loss, how they tie together. Okay?
So
You want to, yeah.
I was just to say I had that happen on a closing a couple years ago. There was a minor hurricane that kind of came through in the lower keys. We were closing in the upper keys, but because of the radius, we had to have the property re-inspected.
Mhm. Yeah, that's usually what happens. That's usually what happens. So you can modify terms. And again, if you're going to have to go beyond what's already stipulated, the 7-day provision and the 30-day provision beyond closing, I would suggest you clean it up with an addendum. So it's clear, but I also suggest that best practices when the force majeure event occurs, make sure you are notifying all the parties that you're invoking the force majeure. It's, self-invoking, but, we're affected by it. This is the date. And so that everybody's on the same page. Okay. Clarify specific dates instead of relying on the rolling extension. And then you can look at gray areas. Okay. Is there a partial ability to perform against the contract? Okay. Then are there parts of the contract that you could move forward? Okay. Or are there parts of the contract that are going to be delayed? Provisions within the contract to be delayed. Okay. Okay. Okay, this is the actual provision. I'm not going to read all of it to you. It does expand some of the things that can trigger it. It goes on. We talk about acts of God. We talk about transportation delays, wars, insurrections, civil unrest, acts of terrorism, governmental actions and mandates, government shutdowns, epidemics or pandemics. So the definition of triggering events is a little bit broader in the contract itself than what I put in the summary. Okay. Has anybody ever had to deal with this besides Jeff and I? Shanti, you have. Anybody else?
I also had it happen where it actually only delayed us one day, but the lender, their computer systems were hacked.
Oh,
And they could not access any of the documents for my buyer.
mhm.
And so we had to wait for that to rectify itself.
So if that clear that, that's a delay, but I don't think that falls under force majeure. Do you, Jeff? If they're
I
being
don't know.
hacked?
I guess it would depend on who hacked it.
Yeah. 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 Well, again, it's not uncommon. These things do happen. And the point today was to make you aware of it since we're coming into part of the year where this can be an event. So any questions on
Well,
what we've talked about so far? Yeah.
just a question on that. Would it be considered because it was a government agency?
The lender?
Yeah, VA. Sorry, VA.
Oh, is VA? I don't think so. I
You
don't.
think so? Okay, I just because it read government, so government. So
Well, it talks about government shutdowns, and governmental actions and mandates. So I think it's more, I don't think that would apply to a single event like that. I would guess if it was a broader hacking, maybe. I don't know, but it's interesting that they don't address that. Um, this was changed right after the pandemic. And they broadened it. And I can remember when they did that and they put in wars and they put in terrorism, they did that at the same time. So, but that's an interesting question though, about hacking, depending on the source, I guess, if it was a government action or not. So, question about any of this. I would ask you to read this. And if you have questions about it, get a hold of me, get a hold of Frank, get a hold of Jeff. and we'll go over it with you because it can be somewhat confusing. So,
I have a question, Ruth, about how it plays out with insurance. If worst case scenario, something happens to the house, do you have to go reevaluate with your insurance that if they're going to still give you coverage? How does it usually play out?
well, we're going to talk about that. How does it usually play out? If there is, we're going to talk about substantial damage in a minute because the risk of loss provision and this kind of play together a little bit.
Okay.
And if there is substantial damage, which is interesting, which we're about to talk about, the contract does not define substantial damage. So we're going to look at that just about now. So good question though, Jim. So here we are, risk of loss. Okay. So the provision in the contract, we'll start with this. What happens if the property is damaged or destroyed prior to closing? The seller bears the risk until closing, and all risk of damage or loss remains with the seller. Okay. How the contract applies it under the risk of loss section, the seller bears the risk until closing. If the property is damaged before closing, the seller must restore the property to substantially the same condition as of the effective date. And of course, excluded is ordinary wear and tear. Okay. If the damage is not restored, the buyer has options depending on severity. Okay, so we're going to get to substantial. What you're talking about, Jen, is substantial damage. So, okay. The actual clause apply, and this is actually the wording from the clause, applies to fire or other casualty losses and the cost of restoration, which includes cost of pruning or removing damaged trees, does not exceed 1.5% of the purchase price. If restoration is not completed by closing, a sum equal to 125% of the cost to complete, not to exceed 1.5% of the purchase price, will be escrowed at closing. If actual amount exceeds escrowed amount, seller shall pay such actual costs, but not to exceed 1.5% of purchase price. Unused escrow is going to be returned to the seller. So this is dealing with casualty loss. Okay. All right. So it caps the seller's responsibility to 1.5%. Okay. This does not cover substantial damage. Okay. So when does it become a substantial loss? It rises to substantial loss when repairs cannot be completed before closing or damage is material. All right. It's not cosmetic or minor. So examples can be fire damage, hurricane flood damage, structural damage, major systems destroyed, significant mold or water intrusion. Okay. Is that kind of going where you want to go, Jen?
Yes, I understood that it's on the seller until closing. I just wonder what outs the buyer has and
Well, we're going to get to it right now. Okay. So
Okay.
substantial loss means damage or destruction to the property that material affects its value or the buyer's intended use, such that the property is no longer in substantially the same condition as of the effective date or required maintenance standard. There's another provision in the contract that talks about required maintenance. Okay, it's a very short provision, and what that talks about is the seller needs to maintain the property in the same condition as it was as of the effective date of contract. So that's very simple. It's making sure that the pool is maintained, that the landscaping is taken care of, that the house itself is maintained inside and out as it was at the effective date of contract. So that's normal maintenance. Okay. All right. So to answer your question, what's the buyer's rights if substantial loss occurs? If the loss is substantial and not cured, okay, and this would be by the date of closing, the buyer can terminate the contract and receive a return of the deposit. They can proceed to closing and they can receive the insurance proceeds and any seller credits if the seller is now going to accredit amounts of money to cure whatever the damage is. Okay. What you would be doing if the buyer elects to move forward is absolutely, they can invoke a new inspection. Absolutely. All right, so you're going to have to write an addendum to the contract to deal with if the buyer's going to move forward their rights. Okay, and if they're going to accept insurance proceeds, if the seller's going to credit anything. Okay, does that answer your question?
It does, thank you.
Okay. Okay, so if damage occurs, minor damage, the seller has to repair it and buyer proceeds to closing. Substantial damage, buyer makes their choice. They can cancel, get the full deposit returned, or they can proceed, they have the right to take the insurance proceeds. They can negotiate credits with the seller. They can institute a new inspection period. And of course, you would be writing an addendum to the contract to cover all of those things. But again, the contract, other than going back to what we talked about a minute ago, material affecting the value of the buyer's intended use. Okay, that's the definition, such that the property is no longer in substantially the same condition as the effective date. That's the definition. It does not define it in terms of money or percentages, other than the cap on the minor casualty loss at 1.5% of the purchase price. It doesn't address anything beyond that definition of substantial damage.
The insurance usually has a deductible.
Mhm.
So we all know that the actual proceeds from the insurance company is not going to cover it.
Right.
So there's an assumption there that the seller has to contribute, or
Well, no, it's not an assumption, Pam. You're going to have to write it very clearly in the addendum that if there is a deductible, okay, the seller's going to be responsible for the deductible, and the buyer would then get the proceeds from the insurance. But again, it's a point of negotiation between the two parties.
right, because that's making the assumption that the insurance proceeds plus the deductible will cover all the damage, which would be why you need another inspection.
It's not, I don't think it's making that assumption. Okay, it's saying that the buyer and seller, if this occurs, they can negotiate, but the buyer can, under certain circumstances, they can take the insurance proceeds. Okay, what surrounds additional monies to repair the damage, deductible for the insurance isn't going to cover. Lord knows, when we have hurricanes, my insurance certainly didn't cover. You know, it was a small part of what, we had to pay. I'm sure that happened to all of you. So again, that's a negotiation between buyer and seller as to, and is the seller in a position, by the way, to make the repairs? We had that happen with a number of these things when Irma came through, that we're trying to negotiate something and the seller didn't have the wherewithal, they didn't have the funds, to be able to pay for some of these repairs. Okay. We did in a couple of cases. What did we do? We reduced the purchase price. Okay. We reduced the purchase price. The buyer was happy with that. We rewrote the contract that way. We amended the contract, reduced the purchase price. We moved forward that way. Okay. So again, it gets to when these things occur, it's not cut and dry. It's not black and white. Jeff, would you agree that it's something that you have to sit down and negotiate between the two parties?
Yeah, Irma was the last time I dealt with this in Naples, and it was mostly screen enclosures and roofs, and every deal comes to a grinding halt, and you just have to sort through each unique situation individually, and it's not easy. Things get delayed, and nobody ends up completely happy. But it kind of resolves itself. So,
yeah. But again, it's to Jeff's point, it does resolve itself, but it really is the two parties coming together and see, does the buyer really want to move forward with this house? Does the seller have the wherewithal to cover, all of this? And a lot of times people don't. A lot of
I think
times
if I
people don't.
remember correctly, the insurance proceeds can be assigned
Mhm.
somehow. I'm not sure exactly how that
Yeah.
works, but the insurance companies are used to dealing with this too. So,
Mhm. Yeah. So, there are options. There are options available. We had a house under contract in Big Pine. Um, and Irma blew through. Big Pine got hit pretty hard, and we had a house that there was a fairly good sized boat suddenly not theirs, ended up on their property, and it was standing perpendicular and leaning up against the house. Okay. So now we have that scenario, and the buyers wanted to move ahead. Buyers and sellers, there was the complication of the third party that owned the boat. That was a whole separate issue. But and there was substantial damage to the house as a result of that. But the buyers and sellers were willing to sit down and negotiate. And it was a situation too where there was limited funds available on the seller side to deal with it. But we were able to. The agents got together and they were able to work out a deal. So now we're talking about substantial damage here, right? In Monroe County, and I'm not going to get too far into it because it's something I think that needs a lot more attention than here, is if you look at our general information on downstairs enclosure, Monroe County has something called substantial damage and the 50% rule. Okay. It's a discussion that we'll have on another day because it's a pretty involved discussion. There is a definition of Monroe County as to what substantial damage is from their perspective and their perspective with regard to issuing permits for repair. Okay. So I would ask you to take some time, read through that general information on downstairs enclosures. So you get a sense of how Monroe County views this and what actually happens when we have a circumstance like this with regard to being able to actually repair the damage, because there are limits that the county will allow. And it applies to all structures. Okay, it used to be kind of limited to ground level, but it's not anymore. It applies to all structures. So you have their definition and how it would affect the property owner or potential buyer. Okay. If there is substantial damage as defined by the county, if they go to make these repairs. Okay. And it can get very, very complicated. Okay. So outside of what the contract says, we have the local jurisdiction here and how that can affect it. So it's you need to understand it. We're going to talk more about it. I think Jeff and Frank and I, I'm going to talk to Brian, and I think it's time to really have a good session on understanding that whole process. Has anybody had to deal with the 50% rule? No? Okay. All right. So I think it's something we're going to have to talk about. So force majeure and risk of loss. Force majeure does not override risk of loss. They're two separate things. All force majeure does for you is it gives you time. It's an extension of time. Part of that time is spent assessing damage to the property, allows for the casualty repairs, minor repairs to be done. But risk of loss, then, depending on what we're looking at, if it is substantial, and again, here in Monroe County, depending on when we look at this, and understand that maybe there are going to have to be permits issued or there's going to have to be substantial work to the property. That brings Monroe County into it. And that's where your buyer has to be educated. The seller has to understand what the county is going to allow or not allow. And then that really gets to be the decision point. Okay. So in Monroe County, it's more than just what the contract provides. Okay. Anybody have any other questions or concerns about anything that we talked about today? Okay. How many of you have dealt with buyer default? None of you have ever dealt with buyer other than, no? Jen, didn't you have a buyer default?
In
thought you
Michigan, I
did.
have,
Yeah, in Michigan you have, but not here. Okay.
not here. No.
Jeff, do you have anything else to add to this?
No, I think it was valuable. Good job.
Well, thank you. Thank you. Any questions anybody has while you have us here, that you would like to ask? Because we're ending a little bit early. So if there are anything else you'd like to ask of us, I don't think Frank is on this, is he? Anybody have anything else that they would like to ask while you have us? Okay. All right. You're all unusually quiet this morning. But again, thank you for your time this morning. I do really want you to go back to the general information on downstairs enclosures. And I really want you to, it's all very, very valuable information, but I really want you to look at item 5. Okay. So you understand what the county can do or not do.
I
if
guess I
there is
have a
problem.
question.
Yes, ma'am.
This is Elizabeth.
Mhm.
What would an act of God be? It says "and act of God," so a hurricane and that is not considered an act of God, I would suppose. I was just trying to figure that out. It's not like super important. It's just curious.
Well, you'll see that term all through legal documents, and you'll certainly see it in insurance policies. My view has always been, an act of God to me, honestly, was a flood, a storm.
Mhm.
That's how I always looked at it. I don't know, Jeff, have you got a better definition than that? So, that's Elizabeth, that's actually how I always looked at it. An act of God is something that's out of, to me, it's a natural maybe a better way to look, it's a naturally occurring event, like a storm or something like that. It's not something that occurred as a result of the action of human beings. So
Okay.
So it's
I don't know. That's my interpretation. Right or wrong, I don't know, but that's mine.
Thank you.
Okay, you're
if
welcome.
you look at ChatGPT, it says natural disasters, earthquakes, hurricanes, tornadoes, and floods, lightning strikes, wildfires, volcanic eruptions, and tsunamis.
There you go. Okay.
Thank you.
That's pretty broad. Okay.
Mhm.
All right. Well, unless anyone has anything else, I want to thank you for your time today. Feel free to call us. Give me a call, give Jeff a call, give Frank a call. And again, on this 50% rule, I want you all to make sure you start to read that. And we're going to get back to you on that in fairly soon, a session on that and some other things. Okay. All right. Well, thank you all. I appreciate it.
Thanks, Ruth.
And
Thank you.
Ruth.
I
Bye.
will see you soon. Take care. Bye.
Thanks, Ruth.
Have a good day.
You're
Thank
welcome.
you.
You too.
Thank you, Ruth.
Bye-bye.
Bye.
Bye.